Welcome, everyone. I think we'll just get started in 1 minute. Great. I think we should get started. It looks like we have a great group here tonight. Thank you all for joining. Good evening for joining our session on New York's Environmental Rights Amendment, or often referred to as New York's Green Amendment for communities. Just a couple programming notes. There's a place to provide your questions in the Q&A function of this webinar, so please leave them there and we'll get to them at the end of the session. My name is Kate Kurera. I'm the Deputy Director at Environmental Advocates NY, a state-based environmental advocacy organization based here in Albany. And before I introduce this very impressive panel, I wanted to start by sharing a brief history on how the Environmental Rights Amendment came to be in New York, because it's a story that started with impacted communities, and that community being Hoosick Falls, New York. Hoosick Falls in 2014 discovered their public drinking water supplies were contaminated with toxic PFOA. EA started helping that community advocate for the state to respond to the cleanup and the treatment of those contaminants. And during the course of that advocacy, we sat in rooms with moms and residents who continually asked us, don't we have the right to drink clean water? At a similar time, a victory had occurred actually in Pennsylvania, where a constitutional environmental right had been revived in a court decision, where the right was used to strike down a pro-fracking state law. Advocates looked at that victory and the power of the constitutional amendment in Pennsylvania, and we began on a similar course and process of advocating for an environmental constitutional right here in New York. And after many years of advocacy of the state legislature to get the amendment passed by 2 consecutively elected state legislatures, it was put before the people of New York last November, and 70% of voters voted to approve this measure. And that's where we start today. And we have this new amendment to our Constitution. So I'd love to jump in and introduce our panelists. I'll first start with, maybe just give a wave when I say your name, Maya Van Rossum. She served as the Delaware Riverkeeper and leader of a 4-state organization, the Delaware Riverkeeper Network, for 30 years. While she serves in this role, in a recent years, she's founded a national organization called Green Amendments for the Generations and authored 2 books entitled Green Amendment, all focused on advancing constitutional environmental rights that meet the definition of what Maya calls the Green Amendment. Her Green Amendment work is taking hold in over 15 states at this point. Professor Rebecca Bratspies teaches at CUNY Law School. A scholar of environmental justice and human rights, Professor Bratspies has written extensively on environmental justice, including environmental justice law, policy and regulation, and 3 environmental justice comic books, Maya's Lot, Bim's Plant, and Troops Run. She serves on New York City's Environmental Justice Advisory Board, the EPA's Children's Health Protection Advisory Committee, and is a scholar at the Center for Progressive Reform and a member of the New York City Bar Environmental Committee. Anthony Karefa Rogers-Wright currently serves as the Deputy Director of Environmental Justice at New York Lawyers for the Public Interest. In his capacity, he guides and coordinates organizations' EJ strategy, litigation, policy and organizing, and advocacy initiatives. He's written numerous articles, book chapters showcasing the axiomatic nexus of climate crisis and racial injustice, and has spoken on the issue at various conferences and universities throughout the US and Europe. He's acted as a climate justice policy advisor for numerous elected officials and candidates for office, including Comptroller Brad Lander, Senators Bernie Sanders, Elizabeth Warren, Ed Markey, Jeff Merkley, and Governor Jay Inslee. A recognized national EJ leader, Anthony was selected as one of the grist.org 50 environmentalists you'll be talking about in 2016, and has twice been recognized as one of the 100 powerful environmentalists in New York City's City and State magazine. Lastly, we have Michael Youhana, a senior associate attorney at Earthjustice's Northeast Regional Program. Together with his colleagues, he engages in litigation and advocacy and administrative proceedings on behalf of clients who aim to promote environmental injustice, eliminate pollution throughout the state of New York. Prior to joining Earthjustice, Michael was a fellow at the ACLU in Washington. That was a mouthful. Very impressive group of panelists. So I think we should just dig in and get started. And I'm going to start posing questions to our panelists. And really the first question I'd love, Michael, maybe for you to jump in and answer is, can you explain what this right actually is and why it's significant in New York?
Sure. The Environmental Rights Amendment is placed in the New York State Constitution's Bill of Rights. It specifies that it applies to the people of New York. It specifically says that persons are entitled to clean air, water, and a healthful environment. It is a limitation on government actions, specifically the actions of the state of New York acting through the legislature or executive agencies. It's not an absolute right. It is a right on par with other fundamental rights, and fundamental rights include the right to free speech or the right to bear arms, which means that if a government action were to infringe upon the right, it would be subject to a high level of scrutiny, sometimes referred to as strict scrutiny is the technical term. And so it would need to be basically law or action would need to be narrowly tailored and serve a compelling state interest. And yes, thank you.
Can I just add to that, if you don't mind? Because I think it's really important for people to understand that this constitutional right is what we call self-executing, meaning that it can be claimed directly without any additional statutes or legislation or regulations giving it content. On that, it's like the right to free speech, the right to property, the right to freedom of religion, freedom of speech, and it states really important rights to breathe clean air, drink clean water, and live in a clean environment that the government cannot either deny or infringe. And every person in New York holds these rights by virtue of being in New York. It's not tied to citizenship, it's not tied to age. You don't have to live in the right zip code, have the right complexion, or speak with the right accent. Everybody has these rights.
Thank you so much. That's really helpful and very interesting. Maya, I'm wondering if you can jump in and just maybe talk a little bit about, I mentioned before that Pennsylvania has this Green Amendment, and you've mentioned it's taking a hold in 15 other states. Can you just talk a little bit about what other states have this Green Amendment, and also kind of how New York's compares?
Yeah. So the truth is almost every state across our nation, by my count, it's 46, actually talks about the environment in their constitutions. And a significant proportion of them talk about environmental rights and the right of the people to a clean and healthy environment. They talk about it in one form or another. But a Green Amendment is a particular kind of environmental rights amendment. And it does what you've heard Rebecca and Michael talk about, is it fulfills certain criteria that ensures that our rights to clean water and air and a healthful environment are protected in the same most powerful constitutional way we do protect the other human, civil, and political rights we hold dear, like free speech, freedom of religion, as you've heard about. And you've heard a number of ways that those rights are incredibly protected, right? That the Constitution is overarching above the laws. So the laws have to serve the Constitution, that the amendment is self-executing. So it has legal force and effect on its own. And there are a number of ways that our fundamental rights are better protected because they fulfill these critical criteria, among them being in the Bill of Rights section of our state and federal constitutions. At this point, there are in fact only 3 states that do raise up environmental rights to this highest constitutional level, that fulfill what I call the Green Amendment criteria. And that's Pennsylvania, Montana, and now the state of New York. The other states that you mentioned, those other 15 plus states that are looking to advance this approach, right? There are various stages of getting organized. Some have proposed language, some are just in the grassroots organizing stage. But what I can tell you is all of them are watching what is happening in Pennsylvania, Montana, and now New York, because what happens in these 3 Green Amendment states is going to offer critical guidance to what it actually means to have a constitutional Green Amendment anywhere and everywhere. And I'll just add that while our amendment is starting at the state level, because it makes it more accessible, ultimately we do expect to get a federal Green Amendment because we need this kind of constitutional protection at both levels, the state and the federal.
Great. Thanks for that. I'm going to just slow down a minute so that our translators are keeping up with our discussion, which is very interesting. So Michael and Professor Bratspies and Amara, you've talked about how this right is something we hold, right? This is a right that we hold as people of New York. So I was wondering if we could just talk about the different pathways that it can be used by a community to advocate for basically ensuring they have the right to clean air, clean water, and ensuring that those rights are being upheld. So I might start with you, Anthony, because in my mind, there's kind of a hierarchy, if you will, of how this right can be used by the people of New York. And I think one of the most powerful ways, at least for communities and advocates, is to use it as a grassroots and political advocacy tool. And I was just wondering if you could speak and describe your thoughts on that.
Yeah, first, thank you, Kate, so much for bringing this all together and all of this copious amount of wisdom and knowledge and making it accessible. That's an incredible talent. We appreciate you. And then, of course, to our translators, we are really appreciative of your amazing efforts, and thank you for being here and making this accessible for as many people as possible. So I think I'll just build off of what Maya, just stated. I mean, we know for a fact, that this country, our governments, what some people would refer to as de facto racism, or differentiating from de jure racism, is that our governments have actually played a part in selecting certain communities who would be sacrificed. Economic and energy sacrifice zones is a term that is very prevalent within EJ and climate justice communities. And these are communities that were selected to be basically just forgotten about, dumped on, all of the waste, located there, situated there, and people essentially not being given their full constitutional rights at the federal and certainly at the state level. So now with this amendment, Green Amendment, Equal Rights Amendment, some even refer to it as the Environmental Justice Amendment, we have a proactive tool that can work in concert with landmark laws, which you've worked on, Kate, and so work on the Climate Leadership and Community Protection Act, landmark laws at the city level, like Local Law 97 and the Climate Mobilization Act, and really accentuate what those laws are designed to do. And I would say that what's even very salient about the Environmental Rights Amendment is that it's a proactive tool, right? Too often, some of us are attorneys. I work with New York Lawyers for the Public Interest. We have a lot of end of the pipe post hoc solutions. What this does now, it can act as interdiction before anything even commences, especially for communities that our EJ program is accountable to, that are already suffering from years and decades of cumulative pollution. So this is really an answer and a confrontation of previous governmental actions, as Maya and the professor were saying previously, saying that governments can no longer constitutionally select certain communities, all too often Black, Brown, Indigenous, and poor white communities, as the disproportionate benefactors, not even really benefactors, but the disproportionate victims of disproportionate amounts of pollution and toxic exposure.
Thank you, Anthony. That's great. And I think just also a point to make on that is just raising this at every level for advocates, reminding decision makers that this exists, right? And that they have the responsibility and duty now to actually consider it in their decision making, and making that point obvious and bringing that to the forefront of and all of that kind of grassroots advocacy, I think, is really important. I think kind of moving up the hierarchy, I guess, Professor Bratspies, could you talk about how advocates can actually use this right to influence decision making or challenge decision making? Because I think this is a whole nother level of how you insert yourself in the process using the Environmental Rights Amendment.
Sure. I just want to take a step back for a second and just, I don't exactly know who's in the audience, but I just want to remind people that environmental justice is about the fair treatment and meaningful involvement of people and communities in decisions about the environment that affect them. And historically, even though environmental justice is about fair treatment and meaningful involvement, most of what we think of as government action in this context has been about public participation in decision making. And the Supreme Court told us that the laws that we have about public participation, particularly NYPA, the National Environmental Policy Act, and here in New York we have SECR, which is the state, blanking on what it stands for at the moment, so bad with acronyms. But those are statutes that are about process, not about substance. So they are about making sure that people get to participate in decisions, but they have no substantive hook about what the outcome has to be. The Supreme Court said it prohibits uninformed rather than unwise decision making. Well, this amendment changes that. It puts fair treatment, how environmental burdens and benefits are actually distributed, squarely on the table, because now it's not just about process, it's about substance. There's a substantive right to a clean environment, not just a right to participate in decisions. And that creates new possibilities for challenging unequal environmental protection that Anthony so eloquently described. And it also is going to require more and better and more meaningful participation in decisions. Now, where we're going to see, like where the rubber hits the road, where we're going to see this is in a number of different contexts, but the two that we're going to see it in, I think, most immediately is in permitting, because all of the polluting infrastructure that is in our city requires permits from the government in order to operate. And those permits specify levels of pollution that facility is allowed to emit. And those levels of pollution are set based on pretty complicated formulas about national standards. But now the people who live nearby, who have for so long been viewed as sacrifice zones, now they can go in and say, hey, I have the right to breathe clean air. You can't let this facility emit so much pollution that it impacts my ability to breathe clean air. My kids have a right not to have asthma. And pollution and asthma are intimately entwined. And we see across New York that there's a huge racial divide in who suffers from asthma. And Black kids are so much more likely to suffer from asthma than white kids are. And here in New York City, we see there are neighborhoods that are known as Asthma Alley. And then there are neighborhoods where the asthma rate is an order of magnitude less. This is going to be a way to try to change that and to try to bring better, stronger environmental protection to communities that are really suffering.
Great, thank you for that. Is anyone else interested in jumping in? Because I think the last tool that I'm thinking about is litigation, and I think that comes to mind to most when we think about utilizing a constitutional right. But I think in the view of with this right being new, there's a consideration that that's kind of the last resort at this point in time. And Michael, I was wondering if you could kind of talk through that.
Sure. I'll start with the second part of the question, which is why we should think about litigation as a last resort. And so this is just sort of general principles about litigation. Litigation is costly and the outcome can be uncertain, and it can be particularly uncertain at a time in an area of law where there hasn't been much case law developed yet, as in as with this new amendment where there's basically been no case law developed. Case law also tends to develop iteratively. Courts can be sort of conservative institutions, and they're more likely to make larger decisions about upending a sort of regulatory scheme after you've got some case law on the books. And then even if you win a major case, litigation is not always a panacea. And I think back to a bit of advice given to me by my constitutional law professor as we were discussing some of the civil rights victories of the 50s and 60s. He would always point out to students that there was a big time lag between the landmark decision in Brown versus Board of Education in 1954 and the actual dismantling of Jim Crow in the South, which took over a decade of organizing and struggle and advocacy by advocates to actually to make the promise of that litigation victory sort of bear out. And I think that the same is true with any sort of progressive constitutional victory in courts. It's going to take a lot more than just the lawyers making the arguments to the judges to make these rights real. However, the Environmental Rights Amendment can be a powerful tool in litigation, all of those caveats outlined. In particular, basically, as many of the previous speakers has mentioned, it can help fill in gaps where regulation and existing law has sort of failed to regulate pollution and other environmental harms in the state. It can be used as a background principle to help courts as they interpret existing statutes and to push the court's interpretations of the existing statutes in a more environmentally ameliorative direction. It can be used as a tool in addition to tools like SECRA to emphasize that agencies, when they engage in actions throughout the state, really do need to consider environmental harms before carrying out those actions. And lastly, and this is sort of one of the main things that sets the amendment apart from an environmentally beneficial piece of legislation like the recently passed climate bill in 2019, the constitutional amendments can be used to challenge actions by the state legislature. So if New York State were to suddenly renege on its environmental commitments and start to pass environmentally harmful bills, advocates could use the amendment to challenge those bills.
Thanks so much. And interestingly, because maybe Maya will talk about this later, of how a municipality actually used it to attack a state law. So different levels of government actually being able to use it as a defense or as a tool to see progress. Maya, I'm just wondering if you could jump in and really talk about maybe all of these different tools and how they're playing out in different states.
Yeah, absolutely. So I think people have really beautifully explained how the amendment, why and how it is so strong. So, but I'm going to give you a couple of examples of how the amendment in Pennsylvania and Montana have actually been utilized to tremendous effect. I'm going to go over them kind of quickly, but because of time, but they're really powerful stories. So first off, anytime anybody in the Commonwealth of Pennsylvania goes up to advocate on an environmental issue at a public hearing or anything, the first thing they do is they quote Article 1, Section 27, and their constitutional right to a clean, safe, and healthy environment. And in their case, the duty of the state to protect the natural resources of the state for present and future generations. It's a mind shift. It's very empowering for advocates and reframes the conversation in that advocacy context. But when we go to look at how the amendments have actually made a difference in Pennsylvania and Montana, in Pennsylvania, Fracking had come to the Commonwealth of Pennsylvania in the mid-2000s. And while Pennsylvania's Green Amendment had already been passed years before, it had been inappropriately used and interpreted by the courts, and so had been declared to be just a statement of policy and didn't have any real legal effect for literally 42 years. But when the Pennsylvania legislature passed a very excruciatingly pro-fracking law that put in place automatic waivers from environmental protection standards for the fracking industry, that preempted local zoning authority and mandated that fracking operations be allowed to happen in the heart of residential communities with fracking well pads as close as 300 feet from people's homes, when it removed the obligation for the frackers to notify those on private drinking water wells that their private drinking water had potentially become contaminated by nearby fracking operations, and more. I, in my role as the Delaware Riverkeeper, and my organization, the Delaware Riverkeeper Network, along with 7 towns, challenged these pro-fracking elements of that law. So fracking was happening in the Commonwealth of Pennsylvania, but truthfully, it was going to get exponentially worse if this law was allowed to go into force and effect. We challenged these provisions of the law, claiming that they would be a constitutional violation of the environmental rights of the people of Pennsylvania, and based on Article 1, Section 27, and in a decision rendered by the Pennsylvania Supreme Court in December of 2013, we were victorious in defeating those pro-fracking provisions because, in fact, they would be unconstitutional based on Pennsylvania's Green Amendment. In that victory, we defeated the law, and we also literally breathed legal life into Pennsylvania's Green Amendment. And since that time, there have been more victories in the Commonwealth of Pennsylvania. The Green Amendment in both Pennsylvania and Montana have been used, the amendments have been used to defeat permits that have been issued that would have advanced industrial gold mining operations in sensitive ecosystems or in places and spaces that would have had serious consequences for the environment and for human communities. We defeated a permit, had it voided, a permit that was going to allow the spreading of sewage sludge in the heart of a residential area and would have had serious consequences for an exceptional value stream. The Green Amendment has been used at the municipal level, not only in our Act 13 case to defend the right of the municipal, or the obligation, the constitutional obligation of the municipalities who joined us in our litigation to protect the environmental rights of their residents, but it's also been used in decision-making having to do with zoning decisions, and was recently relied upon by a local Pennsylvania municipality to say no to a development project that would have devastated the last remaining piece of green space in a quickly urbanizing town. The Green Amendment, we have relied upon the Green Amendment, again, we, the Delaware Riverkeeper Network, to actually ensure that Pennsylvania filled the gap around PFAS regulation. And through advocacy and then litigation and more advocacy, we actually forced the Pennsylvania government to put in place drinking water standards for PFAS. And that decision, we had a critical final decision on that as recently as today. And, you know, Professor Bratspies talked about the importance of having this substantive right, but there is also a critical procedural element to this right, because having this constitutional right mandates that government officials consider the ramifications of their decision-making before they render it. So before they pass the law, issue the permit, inflict the devastating consequences on the already overburdened sacrifice zones and environmental justice communities. Government officials have to do the work. They have to look at the cumulative impacts. They have to look at the science. They have to look at the ramifications of what they're about to do before they're about to do it. And when legal challenges have been brought forth, particularly to permits, where we and others have been able to demonstrate that the government failed to do this kind of analysis and just checked the boxes and issued the permit that was going to have potentially very significant substantive consequences, that procedural failure, notably to look at cumulative impacts, which is so important in the environmental justice context, that failure rendered the permit unconstitutional. So sometimes it is about the process and making sure we get our voice at the table and get appropriate consideration. And sometimes it is about the ultimate impact substantively. And when you put the two together, you can see, I think just by these examples, it's very, very powerful. And there are more examples, but we don't have time to go into them all.
I just want to add one thing to what Maya was just saying, because she gave us some great examples of how litigation can really change things on the ground. But we don't have to wait for litigation. And, I think that was what you were asking me earlier, and I sort of derailed myself, Katie. But New York's Constitution puts a duty on the governor to take care that the law be faithfully executed. And the governor could tomorrow order every agency in the state to rethink the way that it implements its existing law, regulations and policies in light of this environmental amendment. And, it's my hope that the governor is going to do that. But even without that, every agency in the state, every government actor in the state has a duty to implement the Constitution. And everyone exercising governmental authority has to take steps now to protect environmental rights, to promote actions designed to preserve and enhance these rights, and to take affirmative steps to protect the healthy environment of all New Yorkers. And that's got to mean reevaluating the way we assess costs and benefits in permitting, in road building, in all kinds of activities that governments engage in.
Yeah, thanks for adding that. And that to me makes me think of why it's so important for advocates and community members to understand that government does have that duty, because understanding that there is a procedural step that government has to fulfill and has that duty to. And if they fail to do that, you have a ground, or, you have an opportunity to insert yourself in that process. Like, well, where is your consideration of this right? And you have that duty. So that's great. I wanted to jump a little bit to kind of a little bit more discussion about how it's used to balance the equities in environmental justice and kind of dismantling environmental racism, and how you foresee. I think this is really a question for Anthony and Professor Bratspies, but anyone please feel to jump in, because as we were all saying, it is very powerful. But how do you foresee it? And if you were working with these communities, which we know you do, how would you be advising them to think about the right?
Yeah, I would say first and foremost as a tool, and a tool that needs to be, at least from the outset, it's still burgeoning, it's still very nascent, and understandably there are some who are very circumspect about how to use this right away. We saw a lot of similar arguments when it came to marriage equality. How far do we want to take this? What is the Supreme Court going to do? And I think that what I would say is that, let's use it as a tool, but as a guided tool, right? When we're looking at the arc of civil rights, and that's what this really boils down to, is the civil rights specifically of poorer, Blacker, browner, lower income and lower wealth New Yorkers who are disproportionately exposed to what this amendment is supposed to now prevent. We're going to have to figure out collectively how best to use this tool, right? How best to use a tool like a boycott with the Montgomery bus boycotts. That was an arc that was building up to what eventually became the Civil Rights Act. And we can have different discussions about how effective that act actually is. But what I would say is that's what we're all discussing, Kate, right? That's why we meet every week, is, because what we don't want is sort of like the abuse of a tool, right? We don't want wealthy people, saying that this is going to obstruct my view, and therefore, my constitutional rights are being upended, when that's not what the framers really had in mind when they came up with this tool. So I would say that, if we use it from a community community lawyering lens, which is what New York Lawyers of the Public Interest is all about, as originators of this kind of approach to law, is how do we use it as an organizing tool? You know, how do we get grassroots organizers involved with this who live in communities? We're getting so many salient and important questions right now. I'm just kind of like scanning the chat, and these are really, really important questions, and we're going to have to figure them out together using a community lawyering lens, using a lens that's extremely inclusive with people who are not lawyers, you know, especially probably to figure out how to really harness the power of this new amendment, which, as everyone has been saying, the Professor, Maya, and Michael, this is really the people's amendment, right? So I would say to all these people asking specific questions is let's figure out the format so that we can answer these questions together, so that like we use this tool such that it can really be utilized by the people who are most disproportionately impacted by exposure to pollution, and now the advent of the increasingly more potent climate crisis. Because what we don't want is for it to be abused to a point where it cannot be utilized efficaciously. But that said, I think that this is a really, really great opportunity for lawyers and community organizers and activists and residents to actually work together, because the more that we are able to do that in synergy, the more that we're going to get the fruits of this bill to act as a tool, as we said previously, of prevention from the government consciously or unconsciously selecting certain communities to be economic and energy sacrifice zones. So I mean, it's kind of like unknown like that, right? You know, we go from like who's going to test Brown v. Board of Education. You know, in the end, we know what that took. And I think we're kind of like at a similar moment with a new amendment that everybody wants to use, but we're not quite sure how to do that yet, and we have to figure that out together.
Yeah, and I think there's like a cautionary tale in here too, right? I don't know if anyone wants to speak to that. And there are actually a lot of really great questions, so maybe we might turn to that in a few minutes.
But can I just highlight
Yeah.
that cautionary tale?
Yeah,
And
absolutely.
goes with the answer to the last question I gave, was that really in the Commonwealth of Pennsylvania, while the Pennsylvania Green Amendment was passed in 1971, it was almost instantaneously used in that bad way. And it's like Anthony was reading my mind, because it was actually used to challenge an educational viewing tower over a civil rights war field. It was just an inappropriate use of the Environmental Rights Amendment in the Commonwealth of Pennsylvania. But what it did was, I think it frightened off the Supreme Court justices, and it set bad precedent. And the justices said, this is not self-executing, this is just a statement of policy. And in the legal world, policy is good advice, and you can take it or you can leave it. And in Pennsylvania, they left it until we had that really abusive pro-fracking law. And then we were in the right moment to overturn that bad precedent. But that really is a cautionary tale. We do need to make sure that as green amendments, as the New York Green Amendment is used, and as amendments are passed in other states, that we are using them wisely so that we are setting good precedent. And I did just want to offer in the environmental justice context, to add to what Anthony said, I think one of the incredibly powerful things about this constitutional environmental rights amendment is that the demonstration of disproportionate impact should be enough in the environmental sacrifice zone context to raise a constitutional question. As long as, again, we're not doing low-level differences. We can really show that there's a disproportionate impact that is happening or will happen because of government action and activity that is proposed or taking place. That should be enough to raise the constitutional question. And then there is also that procedural element that I talked about. If in the context of issuing that new permit for that highly polluting industrial operation, that really is a demonstration of environmental racism yet again, if not only can you show the the disproportionate impact as a ramification of that permit, but you can show that in the decision-making process, there was not a consideration of the existing condition where these communities of color or low-income communities were already being sacrificed. If you can show that there was scientific data and evidence of the increased level of harm and increasing level of harm that government officials failed to look at, if you can show those kinds of analyses that should have taken place but did not take place because the government just decided to do exactly what the regulations said that they were able to do, then you may also be able to have a constitutional challenge. So it could be procedural, it could be substantive, it could be a combination of the two, but it is that failure to consider the ramifications for environmental justice communities or that demonstration of disproportionate impact that in and of itself should be able to raise a constitutional question. You don't have to show racial intent.
And we shouldn't have to go to court either. You know, this is, I think, the arguments in the first instance that we should be making to local governments, to regulators, to people who are making choices about where infrastructure is going to be located and how the benefits and burdens in our environment are going to be allocated, where the trees going to be planted, where are the bike lanes going to be, where are the power plants going to be. Right, New York is in the process of redefining its energy system. Where are the undesirable uses going to be? Are they going to be burdening communities that are already overburdened? If so, those communities can show up en masse at the hearings and say, our constitutional rights are at stake here. You, decision maker, whether it's the PDC or DEC or whoever it is, you have to think about this differently. And it's a really powerful argument to make to the frontline decision makers way before we get to court, that you have to do things differently now.
Just one layer on that, but the one of the things is every time we do get forced into court and we have a success, then we offer clarity on what it means to have this constitutional right. So that procedural obligation that I mentioned, I can right now off the top of my head reel off 3 cases in Pennsylvania and Montana that set that as an obligation. So therefore, when you go in with your advocacy, you don't just have the power of the Constitution, but you have the power of the Constitution interpreted by court precedent, right? And that offers that clarity. So it really is the combination of advocacy and when we have been forced into court, taking those successes and putting them to work in our advocacy and the combination of the two. And every time we have a victory, that local land use case that I mentioned, that had nothing to do with litigation. It was pure advocacy and municipal officials wanting to do the right thing and being empowered by the Constitution. So it really is that combination that's so incredibly powerful. And you all coming to an event like this and getting this knowledge so you can put it to work in whatever way works best for you with the challenges that you're facing.
Thank you. Thank you all for that. It's such interesting. So I have a couple more questions, but I actually think many of the questions I still had might be answered through the chat because there's some really great questions in the chat, and I want to make sure that we're answering some of the audience questions. So I'm going to just jump in and start reading a couple, and feel free. I may direct it to one person if I think, and then I'll jump in. So the first question I have here is for Raymond, or from Raymond, and he says, in general, how can this amendment be used to stop the environmental degradation committed by private actors? And we haven't really touched on how private actors do or do not fit into the scheme, but I'm wondering if Professor Bratspies, you want to take that, or Michael? You're on mute.
I realize that.
Sorry.
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 It is, my computer is giving me dips. Why don't you talk, Michael, while I try to sort this out?
Yeah, well, like so many things about this amendment, whether or not it basically covers the actions of private actors has not been decided by any court, but we can assume based on how other fundamental rights have been treated up until this point in history that it only covers state action. That does not mean that we cannot use the right to help regulate the actions of private parties, and oftentimes this will regulating the action of private parties will happen in the course of an administrative proceeding. So, for instance, a party may, let's say, apply for a permit to discharge into a lake in New York. That party will typically be maybe like a private industrial facility. They will have to apply for the permit from a state agency. And we will say that the state agency is bound by the Environmental Rights Amendment, and they cannot issue the permit to the private party without taking full account of the rights. And so it's sort of an indirect route to regulation of private parties through the state, which they need to interact with in order to engage in their private activities. And I'll kick it over to you, Professor Bratspies.
I don't have much to add to that. I think you did a great job of explaining it.
Yeah, that's great. And actually, Michael, this was something I was going to ask, but it's also a question a little specific. So how, and you touched on this a little bit, how will this amendment interact? The question is in particular with federal law, but I have an addition to that with federal and state law. And you talked a little bit about secret, but perhaps discussing how it would interact with federal law. Could it compel the EPA to make different decisions in New York?
Well, I think that there's an issue with federal supremacy that may come up, and these, again, are questions that would need to be litigated. However, a lot of EPA's duties in New York, particularly in the clean water space, are delegated to the Department of Environmental Conservation. And so what will end up happening is the Department of Environmental Conservation will look to a federal statute like the Clean Water Act or the Clean Air Act and implement provisions of it. And in DEC's or the Department of Environmental Conservation, the state agencies, interpretation and implementation of the federal statute will be constrained by the Environmental Rights Amendment. And so there is an interaction with federal law, but once again, sort of like the private parties issue, I think it would be a sort of indirect route to shaping federal law as it's implemented in New York State. But I will also kick this question over to the rest of the panel because it is a sort of novel set of questions for me, and I'd be curious to hear what you all think.
Federal environmental law generally uses a process that we call cooperative federalism, where the federal government sets standards and the state implements them. But it's pretty clear for very many standards, particularly in the air quality context, that federal standards are a floor, not a ceiling. There's nothing in the Clean Air Act that says that states can't have more stringent air quality standards, or and there's nothing in CERCLA, the Superfund Act, that says that states can't require cleanup to a higher level. And so this will spur activity in New York, but I don't really see the federal government interfering with this.
And just,
go ahead, Maya. Sorry.
no, Anthony, you go ahead.
No, I was just going to say I would totally 100% agree with the professor. I mean, but Michael is right. We're probably going to see some of this like put to the test. We have a slew of projects that are slated to be potentially permitted and at least proposed because of the Inflation Reduction Act, and prior to that, the bipartisan infrastructure framework that also was passed. So this will be put to the test. We do have some more stringency here in New York. And I would also say that there's probably plenty of case law in California where NEPA, National Environmental Policy Act, many times conflicts with California's more stringent California Environmental Quality Act. So there could be something instructive there. California is a very tough place to get things permitted when people don't want them. But I think that also this, to your question, Kate, this is really going to open up larger questions now that we're talking about this idea of permitting reform to get renewable energy projects and transmission lines approved and fast-tracked. and we're probably going to be answering a question. Yes, can renewable energy projects and transmission lines be environmentally racist? I mean, that's a rhetorical question, but to Michael's point, this is going to be put to the test soon. But I also agree with what the professor just said, that like nothing in federal law is stopping us from being too stringent, or more stringent, which is probably why some people are seeking permitting reform in the first place.
And we are going to have to look in those situations where there is clear preemption at the federal level, for example, with fracked gas pipelines, right? And so when we're looking at how and when we're going to utilize the amendment, we do need to be mindful and make sure we are staying focused on that state action, even if it, right, if whether there's a federal law at play or a state law at play, we want to be sure that we're only using the amendment on that state action or actor. And I have heard and seen people say, well, can't we use this against the Department of Defense on PFAS and other things? They're federal, right? So we want to make sure we stay focused that way. And I do just want to highlight that there have been 2 instances where the Pennsylvania Green Amendment has been raised in the federal court context. As recently as a number of weeks ago, we got a decision where 2 state legislators were trying to rely upon Pennsylvania's Green Amendment to undermine the ban on fracking. And the federal court wonderfully did not take the legislators up on the opportunity to misuse or abuse the Green Amendment, and in fact relied upon the state Supreme Court interpretations of the amendment to turn the legislators away. So we do have 2 examples where there have been efforts and where the courts have constrained themselves. But again, we all ourselves, as we're thinking about those best early test cases, when we're talking about those court scenarios, we want to be sure we're being very mindful of that, of the precedent that we're setting. And the final thing is just to say, in our Green Amendment movement, as I said, when we reach a critical tipping point with state after states getting green amendments, we will organically know it is the right time to turn to a federal green amendment, because we do need one. We do need a federal green amendment to constrain those federal actions. And that is part of our long-term strategy.
Thanks for that. We move on to a couple more questions here. I guess this is somewhat similar. Are there any examples of similar amendments being used in other countries? Yeah, or Anthony, anyone who.
Yeah, the closest that I mean that I can think of where I know this for sure and where I've experienced it. I as you know, spent a couple of months in Colombia this past summer, which just inaugurated a pretty leftist government. There is Colombia Law 70, which actually is affirming the rights, and including the land rights and the rights of Black Afro-Colombians to clean air, clean water, and a healthful environment, and also even repatriating some land back to them. We'll see what happens with that, but I would highly encourage everyone to read Colombia Law 70. It's really, really beautiful. And then, of course, some of the more leftist governments are also talking about, to Maya's point, about literally a green amendment for the environment, right? Like constitutional rights for the environment. So yeah, that's pretty forward thinking as well. When we call them developing countries, it's true, they're developing policies better than we are in some cases.
I think it is Ecuador that's had that for actually quite a while, right? And that's actually giving the environment. And this is different. We've had that question before in New York.
So I do want to say there is, I think it's something on the order of 160 or 190 countries that actually have Green Amendment like language in their constitutions, focused on the human right to a clean, safe, and healthy environment. Some are focused on rights of nature, some are a blend of the two. But when you talk with, and there have been some really important successes, and I do try to cover a few of those in the book, but you know, international law is different than US law. And one of the things that I really like to express is that here, when we're thinking about how to utilize the New York Green Amendment and these kinds of Green Amendment provisions here in the United States of America, we don't have to look to what is happening internationally. We really have really powerful examples, many really powerful examples coming out of Montana and Pennsylvania. I'm anticipating some really good ones coming out of New York, And just the final thing is when, I speak with my colleagues that work in that international arena, really what they say is the conversation is most firmly focusing in on what we actually accomplished in the Commonwealth of Pennsylvania with that pro-fracking law and the incredible power of that opinion. If you're an environmental activist, right, some people say, oh, read a law decision, it'll put you to sleep. If you care about the environment, environmental justice, nature, read that decision, man. It is really compelling. And it was written by a very conservative justice using very conservative constitutional principles to protect the environmental rights of present and future generations. So, but really at the international level, it's a blend, and you're seeing a lot of good language, but there are not a number of really powerful successes. So I encourage us to look at what's happening here, because that best likens to what we have in New York.
I would just also add that there are a number of really compelling decisions from national courts around the world. I mean, international law is one thing, and of course, the United Nations just recognized a human right to a healthy environment, and the United States voted in favor of that. And that can mean something if we make it mean something. But there are also decisions coming out of the courts in Pakistan, in the Philippines. Those are the ones that come to mind immediately, but there are a number of decisions from the European Courts of Human Rights that have been about stopping pollution in overburdened communities, about protecting forests for future generations, about the kinds of things that we're hoping will happen here in New York.
Great. I wanted to get to this question because this is actually from Lorraine, and she is an advocate for many years and from Hoosick Falls, who's really been on the front lines of that community's advocacy to address their PFOA water contamination crisis. And her question is, I'm an advocate from Hoosick Falls, and we're still being contaminated with a number of regrettable substitute PFAS chemicals. Despite our continued vocal concerns, this issue still hasn't been addressed. Could the amendment be applicable in that aspect?
So yes, I mean, part of the point for this, part of the driving force behind this amendment was the recognition from what was happening in Hoosick Falls that lack of a regulation, a lack of a standard meant that private actors could do whatever they wanted. And that along with environmental justice was the driving force behind this constitutional amendment, to give people a way to challenge actions that were affecting their right to breathe clean air, drink clean water, and live in a healthful environment that weren't covered already by the regulatory context. And that's part of what this is for.
I have a follow-on question, actually, because New York State is going through the process of developing water quality standards and maximum contaminant levels for these PFAS chemicals. We've established one for PFOA, PFAS, and one for dioxin, but there are others recommended. Now, if those recommended levels, one of the fights that we're doing with is that the levels that are being proposed are not the most health protective levels. So there might now be a gap between what is set to be the level that the state is and what the health protective level is. And is there a way for this environmental right to kind of play a role in that?
So I would say there again, yes. And in the first instance, it's going to be in the advocacy situation. And in the second, it may end up being litigation depending on where the number is. And on the advocacy front, one of the things that advocates can do is really turn to the new levels set in Pennsylvania, the levels set in New Jersey, where they are very protective. We can look to what the federal government has said now about the health advisory limit, right? And that 70 ppt, how bad that is and how we need to be so much lower. And so by using the new federal recognition, using those examples in Pennsylvania, New Jersey, and potentially some other states where they do have standards that are around 4, 5, 6, maybe 12 or 13, but certainly not 70. Coupling it with the constitutional right to clean water, I think it can be used very powerful in the advocacy context with a little bit of a threat of litigation based on the Constitution to perhaps avert that bad outcome and get New York onto the right path to really be looking at those very, very low levels that are so critically important. And again, that other neighboring states are already embracing. So I think it's the combination of the two in the advocacy context, and then staging it potentially for litigation, depending on where it looks like New York State is going. But we do have to recognize, right, that just because whether we're talking about PFAS or any other issue, just because the government didn't do the best that they could do, didn't do exactly what we wanted them to do, the difference between what we wanted or science may demonstrate would be most beneficial and what is scientifically defensible and or defensible in terms of environmental protection, that may not rise to the constitutional level, right? So again, it's about, just because we don't get what we wanted, it doesn't mean that we didn't get something protective that is within the constitutional realm. So again, it's about being mindful and picking those best early battles to set that good precedent that will help us over time strengthen the bar on environmental protection and environmental justice.
And I think that goes to, I mean, maybe Michael, is something we could talk about the deference that administrative agencies are often given, right, in setting those levels. So Maya, what you're saying is that even if we don't get that what we're saying, we're asking the most protective level, that actually might not be a violation, right? The government still may have done their duty and discharged their duty in making that decision, even though, and the agency actually using and having deference, and the court perhaps giving deference to the agency in that process. Here's a question, which I know we've all want to answer. Have there been any cases filed thus far in New York using the Environmental Rights Amendment? And I know we know of a couple of things that are happening. I'm wondering if a couple of you want to chime in to provide some insight to what we know, which is a little.
I guess I'll just, as the non-attorney, from the reaction that I have seen from the attorneys who I do get to work with, and with you, I take it that we are not thrilled with some of the usage of it so far, but I'll leave it to everyone else to speak to. But there are things happening, as you said, indeed.
Well, and I think sometimes the way cases are reported in the press or the way cases are spoken about aren't actually an accurate representation when you actually get down into the weeds of what the attorneys are doing. And I've seen that a lot. Sometimes somebody will talk about any kind of case. I'm not talking about these New York cases. You're like, what is up? And then when you actually read the briefing, when you actually talk with the parties and get a real sense of what's going on, you say, oh, now I understand what you're doing. So I do want to, there's a little bit of a cautionary tale for people who are reading the press, that reading the press is very different than reading the case. And I just know from myself, you know, I don't want to game out what may happen here. I am just hopeful for a really powerful, good outcome, and that the justices see the wisdom in Article 1, Section 19, and the power and importance of it, and that if they render a decision that touches upon it, it is positive and helpful. And also recognize they may render a decision that doesn't even speak to the Constitution, even though the argument may have been raised, right? There are a lot of ways justices can get around things. So personally, I don't want to game it out. I'm just going to really be hopeful that we get some best first outcomes, and forever remind everybody that Pennsylvania was a big cautionary tale. And the civil rights movement that Anthony talked about, right? We got some really bad decisions that really embraced racism and allowed it to be perpetuated until we had somebody bring a really super smart decision that turned it all around. So let's not put ourselves in the position of having to do that in New York.
Thanks for that. And just to let the audience know, we are going till 8:30, so I'm going to continue to pick out questions from the chat. If we don't get to them all, feel free to send them on afterwards, and hopefully we can help respond to them all after. Here's another. Clean air, clean water are both quantifiable. How would the amendment define a healthful environment?
So that's, oh, go ahead, Mike.
I was going to say, I have some initial thoughts on this, and they relate to what Maya just mentioned about being careful about selecting an initial case, because healthful environment is one of the vaguer terms in the constitutional amendment at the moment. I think for early cases, it makes sense to focus more on bringing challenges under the ambit of the language clean air and clean water. As with everything related to the amendment, no court in this state has interpreted it yet. So healthful environment could be defined very narrowly, or it could be defined very expansively. I think I would like to see it defined, this is just my personal opinion as a litigator, as a sort of catch-all term at the end of the provision that basically fills in gaps related to environmental harm that are not in the realms of air and water. And so, for instance, you can imagine contamination to soil or degradation of an ecosystem, or even at a further end of the spectrum, contamination in the built environment, like lead paint, that might lead to environmental hazard to people. But I will pass it to everybody else.
Yeah, I mean, I think it's a great question, and to everything that's been stated in this discussion so far, I mean, things are going to be left to interpretation. There are risks involved, with this new amendment and how we're going to go about defining some of the terminology. What I would say though is that when it comes to environmental justice, right, it's not just quantifiable; it's also about qualifiable aspects, right? Yes, quantity of emissions that you're exposed to, but quality of life can certainly also be a metric that is determined by, I think someone, it was the professor earlier, about, rates of asthma, and we can establish that nexus between asthma rates and exposure to toxic air emissions. A healthful environment in that sense, it could be articulated, has been enjoined in that case, illegally enjoined in this case. So there are a lot of there's a lot of quality of life aspects that we're going to have to use our imaginations, but not too much, I would say, to measure what that actually means. And this again is I would really, for attorneys who are on this call with us this evening, to really embrace that community lawyering lens, because this is also, to Michael's point, also an issue of self-determination. We have to ask communities who have been disproportionately exposed to these harms for decades, how their quality of lives have been upended as a result of that. So, and of course, we can't get frivolous, but I think that there certainly are ways that we can go beyond just quantifiable amounts of toxins or emissions that people are going to be exposed to arrive at a junction of this could be reasonably conceived as an affront to someone's quality of life, therefore they're helpful.
And I'm glad that you think that clean air and clean water are clear terms, because the debate in the state legislature was arguing that those are just way too ambiguous. We can't possibly know what that means. I would say the same is true for a healthful environment. And I saw there's a question about noise, and it seems to me that noise, like the PFAS chemicals for which there are no standards, is exactly the kind of thing for which a healthful environment standard is so important, because it's basically unregulated, sort of like odor. And one of the cases that I don't think any of us actually answered what cases there are under the Green Amendment. One of the cases is a challenge to the permitting of a landfill upstate. And a large part of that challenge is around the odor burden that the community experiences from the landfill. And if anybody lives near a waste transfer station here in New York City, you know what the kind of noise and odor burden that this kind of polluting infrastructure creates. And right now, the only checks on that are nuisance tort law, basically. And that is an extremely difficult way to try to vindicate community rights. So this amendment is, particularly the healthful environment language of it, is a way in to getting at those really important quality of life impacts that are not directly regulated through the kinds of numerical standards that Anthony was mentioning.
And can I just offer one addition? So I think that Anthony and Professor Bratspies and Michael spoke really powerfully and beautifully to the human health importance and values of that healthful term, or the use of the term healthful. But one of the things I do also want to highlight is if you are involved in a situation that is more about ecological health versus human health. And yes, of course, there's a relationship between the two. Please don't misunderstand. But sometimes it is more about the ecological health of a system or a species. And during the advancement of Article 1, Section 19, we spoke with the legislative champions about not including a term that could speak to ecological health in addition to human health. And so Assemblyman Engelbright went to extra effort at the time to offer clarity in the legislative record that a healthful environment is intended to address human health and also ecological health. So if you find yourself in that scenario where it's more about the health or the continued existence of a species or an ecosystem or ecological health, please don't presume that the Green Amendment can't be of service in that situation. It certainly can in the right circumstances and the right set of facts.
Thanks for that. This question actually goes back to, I think, a little bit about what Anthony and Maya were talking about, how, civil rights cases had in the early days produced an adverse, opposite result in some way. So this question is, how do we protect against the fact that the courts have used strict scrutiny in the past to discriminate against disenfranchised communities?
I'm not sure that I'm understanding the framing of the question. Anthony, it looks like you're getting it, so maybe you can help. Because I see the strict scrutiny as a powerful opportunity.
I was going to say, again, not an attorney, but somewhat the same, that because of the plain language of this article now, that it's almost like, gee, bring it on. But I also don't want to tempt fate.
Well, and it is the fact that, again, looking to Pennsylvania and Montana, that Bill of Rights placement that requires that higher judicial standard of interpretation that results in an interpretation of being self-executing, that looks to the plain language. Actually, those elements that get brought to play from a strict scrutiny review, to me, is actually beneficial. And so I think that's why I'm confused by the question, is that it suggests that it's actually not helpful. I think it's actually very, very helpful. And it is the language, the Bill of Rights placement, the strict scrutiny standard that all have been very, very persuasive with very conservative justices in the Commonwealth of Pennsylvania to put forth a very powerful, enduring interpretation of Pennsylvania's language that has been used to, again, defeat legislation, void out permitting, force government action to clean up a long ignored toxic site where otherwise they weren't taking any action, that has helped prevent the misappropriation of environmental protection funds, that has given life to the obligation, meaningful, enforceable life to the obligation to protect natural resources for present and future generations, which is in that state's language. That's not in New York's language. New York's language is different in some important ways, but that standard really has helped bring strength to the interpretation, and been very compelling for conservative justices who, in the absence of those constitutional guidelines for interpretation, might have been inclined to once again weaken or ignore the constitutional obligation, but instead raised it up and gave it that same power that they give to those other fundamental rights. We all know how powerfully those other fundamental rights are protected. That same power now comes to bear for the environment.
I was just
And
going to
Michael,
say,
jump in, sorry.
Maya said fundamental rights, and that's it. We have fundamental rights now that are codified, and you know, I mean, I would go as far to say that, you know, if the legislature, or in this case DEC or government agency, approves a permit or passes a law that infringes upon a right to clean air, clean water, and a healthful environment, a lot of this, you know, more times than not, it's going to happen in what will be designated as a disadvantaged community, right? And we have the wisdom in New York, unlike our federal government, to include race, right? You know, a so-called suspect classification in the determination of a disadvantaged community. So this now gives the disadvantaged community yet another tool. So if for some reason they're not successful in saying, well, Section 7.3 of the CLCPA was infringed upon by approving this, that's something that then they, as Maya was just saying, they have this now fundamental rights, and as well as a suspect classification, seem that they would both be satisfied for this to apply to preventing something, a permit from being approved, or a piece of legislation that, say, for instance, increase the amount of fossil fuel infrastructure in a certain part of Brooklyn, for instance. I'm just throwing it out there. So I agree fundamentally, and we'll definitely see. But yeah, definitely not as afraid of strict scrutiny in this case as I usually am with other cases.
Thanks for that. Here's a good question, kind of moving on to more of the advocacy side of things. On the same notion of reading in the press versus what is actually occurring in the litigation, how can advocates best translate the legal obstacles in litigation in a way that mobilizes and educates the community appropriately to combat the 24 hours, imagine if there were 25 hours in a day, 24-hour news cycle and one-liners?
I'll just quickly say that one of the people who we should give a shout out to as well, Abby Kleiman, who I have the honor of working with at NYLPI, who helped put this on together, is actually in charge with doing that for us at NYLPI, is, you know, creating accessible community handbooks. Like, this is now the People's Amendment, how it can be utilized, and giving them a resource that transcends, as I think adroitly put, the everyday like news cycles, and giving them another resource. So when they're hearing, you know, being bombarded with all of this information, they have a resource that they can look to, and maybe, you know, juxtapose with what they're hearing with the facts that, you know, we hope to be providing to the community. So that's one thing, you know, first and foremost, we have to make sure that the lay public absolutely understands, you know, what this is and what it isn't, so that they can distinguish between, you know, quite frankly, the ambulance chasing aspect of people who will try to use this law or amendment just for that, versus how we can actually use it to advance environmental justice.
And the other thing I'll just offer, so one of the things I don't think we mentioned is that we, the collaborative that have put this webinar, Zoominar together, also have created an informational tool with resources, including that great NYLPI link that Anthony just mentioned, that I believe everybody's going to be getting. So that will hopefully be a helpful tool for you to use. And there are two things I would suggest. One is, you know, I think all the organizations that are part of this event are here to help. And so when there is obfuscation or confusion, or you feel like you need that extra assistance of somebody who's worked with this kind of amendment or has the expertise to help you push back on, some misuse of the language in your community, or you need help to help the community understand how to use it in a certain context or another, I think we all hope that you'll reach out and let us be helpful resources to you. We can Zoom in, we can, I don't want to say fly in because we're not going to use jets, but we could, come into your community and help work with you and make that happen. And I think the other thing I would just also really encourage is embrace the simplicity of what this is. It is one of the reasons why it is so powerful, because we all get it. We all understand that we as people here on this earth have a right to clean water and clean air and healthy environments, that these are rights that belong to us by virtue of the fact that we are people here on this earth, and that industrial operators and developers and politicians should not be entitled to take those rights from us or our children or future generations. And so when people come back and throw things at you like, well, how do you define clean water or clean air? You can go back and say, well, how do you define free speech or freedom of religion, right? Or an unreasonable search or seizure, right? Because we know in our hearts, right? We know where that line is. We know when that line is crossed. We know that this is our fundamental right as people. And so really embrace the simplicity, the real human truth of what this amendment is telling us, that we have a right to clean water and air and a healthful environment, and nobody is entitled to take it away from us. And when they try to come into our community and throw all sorts of BS at us to try to muddy up what that means, just stand up and say, hey man, this is my right. It's not yours. This is my Constitution. It's not yours. I own it and you can't take it. And embrace that simplicity. And I'll tell you, it's one of the reasons why young people in the other states where we're working love this so much, because they say, we don't have to understand constitutional law or the law at all. We don't have to understand, all we have to understand is the truth, that we have a right to a clean, safe, and healthy environment, and you don't have a right to take it. And they really embrace that. So simplicity helps.
And this is, this is part of a broader project of social solidarity. And it's, there's no easy answer to what do we do about the 24/7 news cycle? What do we do about sound bites? Building a society that is on a human scale and puts people at the center, particularly puts the most vulnerable among us at the center, is the project of a lifetime. It's the project of all of our lifetimes, and we all have to do it together.
I think one more thing I would add is just highlighting the fact that this right extends equally to all New Yorkers. And when a dispute is arising between a polluter and a community in one particular area of New York, a bad interpretation of the right in that area can materially affect the lives of New Yorkers across the state. And that's a way to sort of get, I think, attention on litigation from people who maybe aren't immediately in the community, and get them to care about the interpretation of this right going forward.
I feel like these are really great closing remarks from all of the panelists. Anthony, do you want to jump in?
No, I think Maya hit it out of the park, like as we hope Aaron Judge will be doing tomorrow.
Yeah, it's super inspiring to hear all of you talk through that. I see that we're just about at the end of our hour and a half, and it did feel like a marathon, but I think there was so much great information that was shared. I did want to say one thing, which I probably should have said at the beginning of the hour, is that of course, everything said here doesn't constitute any legal advice. And, all of these are opinions of the panelists and not necessarily the opinions of the organizations they represent. And we'll be following up with resources so that you do have some help if you do want to pursue an advocacy strategy, a litigative strategy, and we'll try to provide that in a follow-up email, I think, to people who registered. So I think with that, I thank you all the panelists and the interpreters for doing such an amazing job. And yeah, look forward to working. There's some resources that are in the chat as well, working with all of you as this unfolds in New York. Thanks.
Good night, everyone.
Good night.
Right.